when talking about open meeting law, and open meeting law applies to meetings and requires that meetings be held in public. So the first question is, what is a meeting? And that's a gathering in person or through technological devices of a quorum of the public body. So what's a quorum? A quorum is the majority of the public body. On a body of 7, it's 4 members of that body. If the public body is 9, it's 5, and so forth. If you have less than a quorum, you're not violating open meeting laws by meeting or having discussions. Having said that, to comply with the intent of the ordinance, we'll talk about some more information here in a minute. But one thing I just want to bring up now, because it's on there, but we'll talk about it later. Proposing legal action is problematic. So if you have a quorum somehow gathered and you propose a legal action, it's not a public meeting, that's a problem. But even in smaller groups, you want to be careful with proposing legal action. And so we'll get to this too, but when it comes to public statements, members, especially of council, but your public representatives, you have to speak to the public. You'll do so on the radio, in newspapers. That's normal, that's expected, and that's good. But if your public statements are directed at other members of your public body, that becomes a problem. So because Councilman Gambogi is close to me, I'll say, if Councilman Gambogi is on the radio and he says, encourage my other council members to vote yes on this proposal, it's a problem. If he's talking about a proposal and why things are important and why he feels a certain way, that's okay. So it may seem like splitting hairs, but proposing specific legal action is problematic, especially if directed to other council members. Now, a meeting, as we've all talked about, doesn't have to just be in person. It can be on the phone, on the computer, or through technological means. For example, a text thread or an email thread. That's why when staff sends out messages, we'll say, please don't reply all, because a reply all is a technological meeting in that sense. So what happens if you don't have a quorum, don't have the meeting? There's been municipalities across the state who've been dinged by having a meeting when there's less than a public body. And that public body is the statutorily or regulatory created number of seats. So for example, sometimes we'll have a public body of say 9 members, and it's established that there's 9, but there's 2 vacancies. 5 members still constitutes a quorum. And I was aware of a case where it was a 9-member body. They had 2 empty seats. 2 people didn't show up to the meeting. So 5 people were at the meeting and 1 had to recuse himself. They still went ahead and voted with the 4 people there as a violation of the open meeting law because they didn't have a quorum. So, notices and agenda. The requirement is that a notice has to have enough information so the public is reasonably informed of what's going to be discussed. Now, this becomes tricky in certain cases where, especially where the public comes to talk about an item and may go off topic somewhat. We can't regulate the public. The public may go beyond the noticed item, but that doesn't change your obligation to stay on topic. So we do have some general items like announcements and so forth. Things like announcements is okay as long as we're not proposing legal action and just discussing what's happening. But things like old business or new business and taking action on that, that would be improper. And as it states there, the open meeting law requires a 24-hour minimum notice unless there's an emergency. And generally, Sarah will get things out well beyond 24 hours, but that's the legal requirement. Notice, the exceptions to the notice requirement are actual emergencies. That's the second point there, as I mentioned. Some sort of fire or something that we need to get in quickly to address, we can deal with that. Or where some meeting has been properly noticed and posted and is recessed and then resumes later that day. So who must comply? All public bodies. This includes any subcommittees. So this is another possibly tenuous or tricky issue where we have subcommittees of this board. Just off the top of my head, the Waters Issues Subcommittee is a 3-member board. The Subcommittee on Appointments is a 3-member board. 2 members of that constitutes a quorum. So even talking to one other person about that business is a violation of open meeting law. So if you're on a subcommittee, on a smaller committee, be very careful not to discuss issues of that committee with any other person. And I want to address specifically these subcommittees of council where you have just 2 people talking becomes a violation of the open meeting law. There has to be some reasonableness here. So again, on the subcommittee on appointments, council member Gambogi and the mayor are both members. So does that mean anytime they talk, it's a violation of the open meeting law? Not necessarily, but if they talk about appointments, it would be. So you want to avoid those discussions. But some discussions about the broader council can be had and should be had. So I pointed out this kind of interesting case. There's another interesting question before the Attorney General right now, and I think it illustrates some of the points. There was 4 members of the Arizona Corporation Commission who signed a letter together to the governor to try and advocate for certain action. And there's currently a decision before the Attorney General to determine whether joint signing of a letter is a violation of the open meeting law. And there's a good chance it will be. So you see that even through those different means, you have a potential violation. A letter from council should be voted on in a public meeting as the letter for council. A letter of planning and zoning should be voted on. When you have a quorum signing off on a certain letter, it becomes an action that could violate the open meeting law. Now, this Puente case was a different case that was fairly interesting, where a meeting was held in a hotel, and it was a quorum, essentially, of Republican legislators. And in that case, the court said that was okay because legislators determine their own rules of procedure, and it's a political question. So some determinations are political questions rather than an open meeting law question. But the point made in this case, and review it if you want, it's fairly interesting, is that things that the state do, the state legislature, council and other bodies cannot, because they set the rules. Executive sessions. So executive session items are requested either by me as the city attorney or by other departments, but are consented to by me because it's executive session and based on our rules of procedure and the law. I have to consent to have a executive session on a certain topic. So there's 7 legal reasons why executive sessions are held. Personnel matters, confidential information is to be discussed, where there's discussions of legal advice or property settlement or contract negotiations. And there's a few others, including information that's relevant to a state or federal Indian tribe, and a few others. These are the 4 reasons that we most commonly see. And I guess we should discuss executive session. To me, it's an important factor. It's important to have executive sessions because some of these, and particularly settlement discussions and contract discussions, cannot be had in open meeting. And when executive sessions are not had, because it cannot be discussed, what ends up happening is council doesn't have input. So I think, or a commission wouldn't have input. So rather than limiting the public input, not having executive sessions tends to reduce public input and reduce council input. And you end up having either one member of council or a member of staff making most or all of the decisions for council. So I think executive sessions are important, but for that same reason, it's important that that information be kept confidential. When executive sessions are held, it's still available to members of the public body to attend. but only until a motion is made to go into an executive session. After that, members, it says members of the public body. I'm talking about members of the public are allowed to attend, except for the executive session portion. But the information cannot be shared except for with Auditor General, Attorney General, members of the public body themselves, or with members that, or of the city that are necessary to be told to be able to affect the action discussed in the executive session.
Councilmember Roosing, you have a question?
Thank you. I'd like to go back to executive sessions. Minutes are taken at executive sessions, and can the public file a request for release of public records and get those minutes of an executive session?
No, not the entire minutes. There is public information available, the agenda that shows what was discussed, but the full minutes of executive session are not public record.
Thank you.
Yeah. So some of the potential issues, revealing executive session information. The problem with revealing executive session information is by doing so, it compromises the integrity of settlement discussions or whatever else is taking place. It's potentially a violation of the law when some of this information is confidential by law. And it ends up giving a skewed perception of what happened in executive session by one person that was in the room. So it does put the city in a precarious position when executive session information is disclosed outside of executive session. Failure to advise persons about the confidentiality requirement. This is why we read the admonition at the beginning of every executive session. And remember that legal action cannot be taken in executive session. There is direction to staff, but the legal action happens outside of executive session. Sorry. So, important things to keep in mind: don't poll other members on commission business. Limit your discussions with other members to public meetings. Don't send emails to each other. Distribute information to the council through your staff liaison, and disband meetings when a quorum is not in attendance. I think it's important for members of committees, commissions, and council to understand communication with other members is important. And I don't want to discourage that. But limit discussions on taking action. Never do so in a quorum, and never do so in a way that electronic means. The other is the polling question is big because we talk about daisy chaining, right, or being a spoke in a hub. If one person on a council or on one of the commissions is speaking to each one of the others, that becomes a polling or a spoke on a hub situation or daisy chaining, and it violates the open meeting law in the same way. So it is one of those pitfalls you need to avoid.
Councilman Cambogia, you have a question.
Would it be a violation of the open meeting law if Tom Hutchinson took the entire planning commission out for Christmas dinner?
Yes, Tom. But
Dang, I was
You're off the hook.
but I will say,
Councilmember Roosing, you have a question as well.
I forgot what that question was, but it was a burning question. Oh, I know. It was, can you talk about not hitting reply all on our emails?
yes, do not reply all to emails. No, reply all, and I know that on emails I send out, I always put do not reply all. It is a violation of the open meeting law, or potentially is. Now, I know that different commissions sometimes will slip up and say, thanks for preparing this, or whatever, things like that. And that's not really a violation, but you don't want to get in that game where you're parsing out whether it really is or isn't. Just do not reply all. And it becomes like this, a splintering of the quorum and circumventing the open meeting law, and we want to avoid that. Now, one other, Okay. One other issue that is not necessarily clear within the open meeting law, but I want you to be aware of, is a gathering of less than a quorum to discuss city business. So for council, that would be 3 members, say. If you have a regular 3-person meeting, I would advise against regular meetings of 3 persons, for example, because, and like I said, it's not clear within the open meeting law. And although it's not a quorum and not a violation technically of the open meeting law, there is language through court cases and so forth that say other means or other gatherings can be a violation. And so if there becomes a de facto subcommittee where things are discussed or the next meeting is discussed, it can potentially be a violation of the open meeting law. So just want to bring it up. And like I said, I don't want to discourage communication between council members where, for example, Councilman Gambogi really believes that bike lanes are important and talks to Councilwoman Cantalme or Mayor Pro Tem Cantalme and say, hey, let's do something. Let's request an item about bike lanes. I think that's important. That happens, and I would encourage that. But if the 2 of you got with the mayor and every Thursday had lunch to discuss the importance of bike lanes and what your process was, even though that's not technically a violation of the open meeting law, I think it violates the spirit, and you'd want to avoid that. Okay, 2-way communications that are prohibited, and this is referring to emails among the whole body. So discussing, deliberating, taking legal action, and we've discussed this plenty, that is clearly wrong. But even 1-way communication is also potentially problematic, and that's where one council member sends it, replies all, or sends an email to all the other council members. And if you propose legal action, that's when it becomes a problem. So like I said, if you say thank you for preparing something or it was good to see you, if you sent that to all the council, it wouldn't be a violation of the open meeting law. I would discourage it, but it wouldn't. If one person sent an email to all the other council members saying, hey, you need to vote yes on this action, that's a violation of the open meeting law. So just real briefly, if an electronic communication from one member of the public body proposes legal action is sent to enough members of the public body to form a quorum, a violation occurs even if no member of the public body responds to the electronic communication. Staff email. So staff is allowed and needs to send emails to the various commissions. And your receipt of that information from staff is not a violation of the open meeting law. Now, we'll often get information that one member of council or one member of a commission wants the rest of the commission to know about. That's appropriate. Send it to your staff liaison, who will then distribute it to the rest of the commission. Now, this is sort of like the media I was talking about, internet and social networking. As members of a public body, you are public figures. You will be in the media, including social networks. That's allowed and appropriate. The problem is the direction of these communications to other members of that public body. Whether you tag them in Instagram or call their name on Facebook, do not direct your comments or commentary to other members of the public body. It's to the public, right? The other thing I think it's pointed out here in the second and is important is responses. So, sorry, Councilman Gambogi, but if he's posting information to Facebook and Mayor Pro Tem Cantalme then responds to him, that's a potential problem. So be careful about responding to the social network comments made by other members of the public body. So meeting etiquette, just in terms of best practice, avoid whispering to each other from the dais, passing notes. All of this may not be violations of the open meeting law, but again, speaking about the intent and the public policy and public perception, avoid whispering, privately communicating with one another during a meeting. Now, you asked me about Planning and Zoning Commission going to Christmas lunch. So is that a violation? Yes. But it happens, maybe not that, but it happens that a majority or a quorum of a public body will be at the same place, whether that's a social event, whether it's a location for a grand opening or something like that. It happens. If it's foreseeable that it will happen, let Sarah know or your council liaison to then publish a courtesy agenda. And she will post it and it will say, this is a courtesy notice to the public that a quorum may be in attendance at this social event. No action, no public discussion will be had. But that's then becomes best practice. And so if you know that's going to happen, that will there be a quorum, do so. If you don't know but suspect, it's best to err on the side of caution and post those public notices. If you happen to be at a concert and you see a quorum and it's not been publicly noticed, be very careful about that. Maybe leave or just don't engage in the discussion with other than a wave. So we want to avoid that at these types of social events. Now,
Councilman Gambogi.
Joe, could you go back to that one right there? Quorum talking to individuals before the meeting officially starts. The individuals meaning like members of your board and commission or council, not the public.
yeah, say somebody in the public was just received a great honor, and 4 of you went down to say, hey, good job. And we're just talking about whatever that award they won is. That is not necessarily a violation of the open meeting law, but we're asking you avoid that because of the appearance. It just is not best practice. So yes, 4 members talking to a member of the public before the meeting about anything.
But a council person greeting some members of the public before a meeting?
Oh, that's fine. It's a group. It would be a group consisting of a quorum talking to a member. And like I said, if it was a member who had just turned 104, like we had recently, and it was awesome, and individual council members went and spoke to that person, that's fine. But if there's a grouping of 4 or 5 or more council members talking to this person, it just has that appearance of violating the open meeting law. So, the public forum speeches and community events, I want to touch on this a little bit as it relates to members of council or any other commission going to the events of a separate commission and the potential issues that brings up. And again, this is and it's easy to say council and point to another commission, but if members of council go to, say, planning and zoning meeting, we post all of that as a courtesy notice. So if there's a quorum there present, it's not a problem. But that doesn't mean it's without potential issues. And what I mean by that is if you have, say, 4 or 5 members of council at a planning and zoning meeting, and one of the members of council gets up and speaks to planning and zoning, it could become problematic if action is being requested, right? And so, and I've said this before, I will never tell a member of council they can't speak at one of these other commissions, because as a general rule, that would be untrue advice. You can speak. But I want you to be very careful about it, especially when it comes to calling for action. But if there's a quorum there present, it can also be problematic because then the first person who gets up to speak has a stronger voice than the rest of council. Because if all of council got up to speak, it would then become problematic, right? If you have 4 members speaking to the commission, you're in a meeting. You're in a council meeting. So pay attention to that and just proceed with caution when it comes to speaking to other commissions. And I think it brings up another potential problem where we're defending subsequent actions. Say if we went to litigation, if planning and zoning said no to something and council said no, because of their recommendation, but members of council spoke to the Planning and Zoning Commission. It takes away from the objectivity of that Planning and Zoning Commission. And so it's an advisory body. Planning and Zoning advises council, and if it can be shown that their advice was influenced by the actual decision-making body, it becomes potentially problematic. So again, there's no prohibition on speaking at another commission, but proceed with caution when doing so. Whoops, I'm going the wrong direction, aren't I? Okay, the public's rights. So we mentioned before that the business of a public body is to happen in the public. The public has a right to attend these meetings, to listen, to tape record, or videotape. The public does not have the right to disrupt the proceedings, and do not, except for in some cases of public hearings and so forth, have a right to participate. Now, most of the commissions and the council have made a decision to allow public to participate. That's within your right to do so. But it's not protected by open meeting law. It's not a requirement that you allow participation. Sorry. So what are the penalties? Nullification of business transacted in violation of the open meeting law. That means we have to go to ratify or redo those discussions. Potentially civil penalties to the individual member of the public body, which the city cannot reimburse. Equitable relief is called out as being a possibility. Attorney's fees and removal from office. So those are the potential penalties. So I know I went through open meeting law fairly quickly. Is there any questions on that before we talk about public records law? Okay.
Councilmember Roosing.
If there's an open meeting law violation by some members of the city council, does that mean the whole city council is chastised, or just those ones involved?
It depends. But if and I don't know, chastise seems like a strange word. I don't know if I want to use that, but the punishments that are in effect here, the penalties, are individual penalties. Now, if the public body, for example, takes action with less than a quorum, that's a violation by the public body, and it'll be a public body who will be required to go through training, and the action of the public body will be nullified. So that's kind of the public body, the whole council penalty. The rest of these penalties are individual and would apply to each and any individual that is found to be in violation of the open meeting law. Okay, public records law. Again, public records law and open meeting law have the same overall philosophy, which is that the business of the public should be made open to the public. But it involves any record in the custody of a government entity that has a substantial nexus to government activity. And so anything in your offices is most likely going to be considered public record. If you use your phones or electronic devices for the business, for city business, that information will be a public record. So the presumption is in Arizona is that the record is public. And there are a lot of exceptions, records that are confidential by law and so forth, or when public disclosure and access is outweighed by confidentiality, privacy, or the best interests of the states. That's the kind of catch-all exceptions. There are explicit exceptions and a catch-all exception, but keeping in mind the general rule that, generally speaking, documents that are in the possession of the public body that relate to the business of the city are public record. Okay. So that includes any records that are reasonably necessary to account for official activities. Now, I think and I know we've covered this, I think that you understand public record law generally. It gets more difficult when we are talking, for example, about your cell phones or iPads or your computers that you use for your personal use. If it's government business on even your personal devices, that is a public record. And so it's one of those things to keep in mind as you go through business. If we had a records request for something on Councilman Gambogi's phone about a discussion with the mayor, that would be disclosable. He would be the custodian of the public record, and we'd forward that request to him to disclose that. But keep that in mind. Okay. Any questions about public records law? No? All right, real quick, we'll go through conflict of interest. You see there the statutes dealing with conflict of interest. Again, the public policy is that if you have a personal interest that impacts your ability to make decisions in the best interest of the city, you need to disclose that interest and step away from any discussions or decisions related to that interest. So it applies to all public officers, including boards and commission members, and all public employees. And here's the definition. A public officer who has or whose relative has a substantial interest in a decision of the public agency or in any contract, sale, purchase, or service to such public agency must disclose that interest in the official record and not vote on or participate in the decision or transaction. Most of the time, this is easy and straightforward. If the city awards this contract, your business gets money, right? And then you step away from it, and that's easy, but that is not the situation we face most of the time. And so the question really comes down to, what does substantial interest mean? And that's what it means. Any pecuniary or proprietary interest, either direct or indirect, other than a remote interest. So what is pecuniary proprietary, and what is a remote interest? That becomes the analysis. So a pecuniary interest is anything that affects you monetarily. If you get money, if you pay money based on a decision, then it's a problem. If your property is affected in any way, that's a substantial interest. But then we get into remote interest. And remote interest is just a huge classification of different types of interests that are declared remote by law. It's not a determination that, well, this is a lot or a little. It's defined terms. So, for example, if, again, Councilman Gambogi worked for a different government entity, that is defined in most cases, and ask me if you have any questions, but in most cases, business for another government entity is defined as a remote interest. And so he could still vote on things that impact the other government entity. But again, what do you do if you're not sure whether it's a remote interest or a substantial interest? And again, remote interest is a defined term. It's not a discretionary situation. It's all defined. But first, keep in mind these questions. Will my decision have a positive or negative impact on my interest or the interest of my relatives? Do I have a monetary or ownership interest in the matter? Is my interest other than one of the designated remote interests?
Councilwoman, Mayor Pro Tem, can tell me.
That's definitely a mouthful.
Yeah.
Hey, Joe, let me ask you something about a situation that happened a few years ago, and I don't think it was ever caught, but is this, I'd like some clarification on it. If you're sitting on a board or a commission and you're making a legal decision on a zoning change for a piece of property, mm-hmm. but you know you own a piece of property in the general vicinity and you will profit from the zoning change, is that a conflict of interest, even though the profiting might be on down the road?
I would have to look at it individually, but often, in most cases, if you're part of a big group that's affected by a decision and everyone's affected equally, it usually falls within the definition of remote interest. And so I'll say, for example, if the city is entering into a contract, I'm going to make something up that you won't see instead of something that you will, but say the city had a deal with a telephone provider. And so the city provided a utility of telephone, and everybody in here was residents of the city and had their telephones through the city. And the city was voting on a new telephone provider that would reduce the costs. Well, you'd have a benefit. and all of you would have a benefit, but so would everyone in the city. And you're part of a large group that no one is treated differently, and it then falls within the definition of remote interest. If you're determining a general plan, that would impact you as a property owner in the city. But you're part of a large group, so it's not a violation of the open meeting law. Does that answer your question?
It's as clear as mud. Thank you.
If you're a member, to be more close, if you're a member, if you live in a subdivision that has a zoning decision related to the subdivision come before you, but it's 200 houses and everybody in the subdivision will be impacted equally. Even though there is some way that you may or may not be affected by the decision, because it's a member of that large class, it falls within the definition of remote interest and it would not be a conflict. But to make it easy, if you have any questions kind of generally, please see me. If you want to request for a conflict of interest opinion, I do that as well. And it will be formal and it will be sent to every member of that commission or every member of council. So we can have a discussion informally, or you can have a formal request and I will give you the written response. So I'm used to dealing with remote interest. If it's a specific one, we can just give the opinion on that. But I will say, ultimately, the decision on conflict of interest is up to each of you to determine. It's an obligation on you. The consequences will be to you individually as well.
Continue just real quick.
Mayor Pro Tem.
Joe, just to expound upon that, when you have people that are subject matter experts in the field, and we want to populate many of these commissions, especially the ones that are technically oriented, with people that actually know what's going on and understand. Mm-hmm. But that is a situation where I think there is a potential for conflict. If again, I've had several people approach me wanting to fill this position we just had open on planning and zoning. Right. But they are actively working in the field and would be voting potentially on things that they could profit from. So how do you deal with something like that where they're we don't want to fill every commission full of retired people like myself, but you want to get people in there that understand the issues at hand. How do you handle that when somebody is actively working in the field and potentially will
I think that
profit?
Two ways. When you're appointing members to those bodies, keep that in mind. But also, I'll just say example, and I don't know that this is any case, so this is made up, just to be clear. But if there's a affordable housing commission, which we do have, and the question before that is, which home builder should we contract with? That would be, and then one of the members of the commission wants to get that contract. That's a conflict. But if we should have a program that establishes money to build affordable housing, and conceivably the person could profit in the future, but it's not an allocation of money, that would be a remote interest. So the point's well taken, but it just depends. It's really a factual-based decision, and it depends on the actual action that's being considered.
Councilmember Rusing.
Thank you. I have a question about recusal and disclosure, because we've had several situations where council members will recuse themselves but won't disclose. Mm-hmm. Don't both of them go hand in hand, or can you just recuse yourself and not let the public know the reason why? Thank you.
So conflicts should be disclosed. It's a requirement by law that conflicts are disclosed. There are times where a member of a body may have a comfort conflict that isn't necessarily an actual conflict of interest, meaning they just don't feel they should vote on that, but by law they could. And in that case, they would recuse themselves and wouldn't have to disclose it. So they don't necessarily go hand in hand, but under the law, if it's a substantial conflict of interest, it does go hand in hand. And I will say that as members of staff or as council members, we're not going to investigate your background to determine whether you have a conflict. We're not going to declare a conflict for you. You're expected as members of public bodies to understand your financial and proprietary interest, and then if you have any questions, to seek a formal opinion on it. So this is a remote interest. So remote interest, we've said by law, is not a conflict of interest. You can still vote and participate in discussions. But sometimes where there's remote interest, someone may want to recuse themselves, and that's up to them. But you should also know under our rules, a recusal, or just we don't allow an abstention by our rules. And so it's considered a vote. Even an abstention is considered a vote. So those are some of the examples of remote interest. Again, there's many of them. And like I said, it's usually if you're a member of another public body that's impacted, if you're making a decision that somehow it could relate to your work or your interests, but it's remote, you're a member of a large group. But again, if you have any doubt, please ask for an opinion. Okay, gifts and bribes. Never use your official position to secure and accept anything of value. This is pretty basic. Now the question becomes nominal gifts. And so you are allowed to receive nominal gifts. If someone brings up, for example, a collection tin, yeah, it's nominal. The value is very low. But if you have any questions, ask for a legal opinion. But the general rule is if it has value, especially if it's over $50, it becomes in the form of a gift that you should avoid. Okay. So what happens if you have a conflict and you vote on something? Contracts can be voidable. The affected person may sue, and the courts could assess attorney's fees and costs even to the individual member of council. Potentially, you could forfeit your office or even receive a felony or a misdemeanor. So again, if you have a question, ask. If it's a real tight question, get a formal opinion and you'll get the formal answer. And that provides you some protection. Or tells you not to vote on something. So, any questions about conflict of interest law? Okay. I guess just to repeat, the business of the public should happen in the public, and if you have any questions, seek a formal opinion. You want me to go into the... Okay, and then briefly, the city clerk has a throat issue and doesn't have a very strong voice today. So I wanted to cover and let you know that the city has a code of conduct for boards, commissions, and committees, and rules of procedure for the city council. The main highlight is that business conducted by the various commissions and by council should be done professionally and with respect. So disagreements are understood and expected and healthy, but those disagreements should be done on policy, not on personality traits, and should be done respectfully. BCC members are required to act in the public interest, recognizing that stewardship of the public interest is to be their most important concern rather than any individual interest. And one provision I wanted to share specifically about the code of conduct for BCC members is that they are required to publicly share substantive information that is relevant to a matter under consideration that they received from sources outside of the public decision-making process. So if you're voting on a zoning decision and you have important information that is impacting your decision, that should be disclosed to all members of the public body. So send it to your staff liaison, they'll send it on. But those types of things, generally speaking, the public, going to the concept that business of the public happens in the public, they're also entitled to at least some part to your decision-making process. And if your decision-making process is heavily colored by certain information that the council or commission hasn't heard as a whole, you're required to disclose that information so the rest of the body can hear it and the public can hear it and determine how it impacts their decisions. So, any questions? All right, that is my portion. I'll move back up there. Are you up next?
Rumor has it I have 3 minutes to cover 13 slides. Luckily for everybody, I'm highly caffeinated and I can do that for you all. Do I have 10 minutes? Oh, okay, right on. All right, well, good morning. My name is Brandon Nunez. I'm the HR director for the city of Prescott. Today I'm going to talk about respectful workplaces. Why is this thingy not working? There we go. All right. Again, I have a couple topics that I'm going to cover here. I can make it quick. Why this is important, though, is we have 1,000 organizational members at the city of Prescott. We have 560 full-time employees. We have 200 part-time employees. We have hundreds of volunteers, including you all, boards and commissions, elected officials, et cetera. And we all have a hand in shaping the culture of our organization. And a big part of shaping our culture here, our desired culture, is creating an environment that is full of respect and dignity. It's also important because our policies outline our expectations in regards to harassment and hostile work environments. And ultimately, one of our goals is to stay compliant with the various state laws and civil rights laws that exist. It applies to all. We have our policies within the city of Prescott. We have various policies that address these types of topics. We have a policy about sexual harassment. We have policies regarding discrimination, harassment, and hostile work environments. But ultimately, our goal in creation of these policies is to maintain a workplace that fosters mutual respect and promotes positive and productive working relationships. Our policies are aligned with federal laws. Just a refresher here. Harassment is considered a form of employment discrimination. Here's the legal definition or the criteria for unlawful harassment, unwelcome conduct in regards to a protected class. Protected classes are listed there. Or if the conduct it's considered unlawful if enduring the conduct is a condition of employment, or if the conduct is severe, pervasive, intimidating, hostile, or offensive to a reasonable person. So what we strive for is an environment that's free from offensive jokes, slurs, and name-calling, physical assaults or threats, intimidation, ridicule or mockery, offensive objects or pictures. In this day and age of cell phone images, we ask that you don't share those types of things at work if they're potentially offensive, and any rude gestures or more. So that's what we're looking for. We want all our employees and volunteers to enter an environment where they can thrive. Consequences for harassment. The person who may be the victim, it impacts their ability to do their job. They may enter an environment where they're very stressed. They may quit. They may start showing more signs of absenteeism. For the person who harasses others, likely at the employee level, it could be anything up to including a termination. If it's severe enough, there could be civil or criminal liability. For you all, if an employee comes to you, what do we expect from you? We want you to gather the facts and you can notify HR, you can notify the city manager's office, you can talk to legal. The goal here is that we want to handle these issues as soon as possible so they don't fester within the organization. For our executives, managers, and supervisors, we're considered the employer under the definition of the law. So what we do or don't do reflects on us as an employer. If we ignore the harassment, we may be liable. If we don't handle it correctly, we can be liable. And it's very serious, and we have to take our obligations as an employer representative seriously. Retaliation is also strictly prohibited. Retaliation could include complaints to management about harassment or participating or cooperating in an investigation. retaliation is just as serious as actual harassment, and the consequences are just as serious. So, was that fast enough for you? Final takeaways. Lead by example. We get a lot of questions about, well, what's reasonable? And I feel bad because we're picking on Councilman Gambogi here. If I were to talk to my guy Ted today and say, man, the Eagles really wet the bed on Monday Night Football last night, didn't they?
That's harassment.
Does a reasonable person think that's harassment?
Nope.
Probably not. So we want you to have fun here. We want you to enjoy your time here. It crosses the line when we start talking about race, color, religion, gender, things of that nature. And so just use your judgment. Any reasonable person, I think, would agree that they can define harassment. Sorry. Any questions? All right.
Thank you, Brandon.
That's all we had for you guys today, Mayor.
Do you have a question, Mayor, Councilmember Rusing?
No, I was just logging out,
Oh.
Mayor.
Well, are there any questions from you members of the boards, commissions, or committees or employees?
Thank you, Mayor and Council. I'm Ralph Hess of Prescott, member of the General Plan Committee. Just a couple of questions. Regarding the promoting a topic for consideration, would two members of a committee be able to discuss outside of a meeting proposal for bringing up a topic for an agenda item at a subsequent meeting? That's one question. The other question is, if a member of the committee receives text or email message on their personal accounts, since I'm unaware of any committee members having city accounts, suggesting a topic for consideration to be put on a future agenda, does that email or text message to the committee member become a public record? Thanks.
Yeah, and so the answer is, assuming it's not a 3-member board, but if it's a 7 or 5 or larger, 2 members of a public body can have that discussion that, hey, let's suggest that there's this item we want to discuss. That is an appropriate discussion. As to the question, if text messages relating to that, is that a public record? Yes, that is a public record, even if it's on a personal cell phone. So, and again, when it comes to getting rid of texts or documents, we try to follow and need to follow the recommendations by the state librarian. Now, when it comes to text like that, the recommendation is that it can be deleted after its administrative use. So you have a text message about it, about, hey, let's request this item, and then eventually that item's done, its administrative use is over, you could delete that, and it wouldn't be in violation of the public records law. But as long as it's on your phone, even if it's 10 years later, it is a public record, and you would be the custodian of that record.
Okay, Ralph Hess again, Prescott. Does that apply also if a member of the public sends me an email knowing that, or any member, knowing the member is on a committee and says, member, I'd like you, the member of the public says, I'd like you to place this on a future agenda for discussion among the committee members. Is that also a public record?
In most cases, it would be. Now, so if it's the general plan and some member of the public sends you a message saying, hey, I think the general plan needs to talk about air raiders at Watson Lake, and you have that it's related to your business on general plan, it is in your custody, it's a public record. Now, you wouldn't have any requirement to keep that for any certain time. Because it's a suggestion, you can get rid of it. Its administrative use is over when you see it. But yes, I would say in most situations, and there's a fact-based inquiry that's to be done, but in most situations that would be a public record.
You know, Joe, how best would you advise members of BCC when there are recommendations or requests coming from the public? How should they respond to those to be able to protect themselves from these potential violations?
Well, and while I'm saying it's a public record, I'm not saying that there's any potential violations to it. I think that that's just part of receiving information. As you receive it, if you have it and it's related to your public duties, it's a public record. But once you've seen it, you can delete it. Now, how do you respond? I would leave that up to each of you. I say you don't have to respond. There's no requirement for response. Any response would simply be kind of under the requirements of respect. But I don't think any response to a member of the public presents a potential problem for open meeting law or public record. As long as it's this communication between a member of the public and a public body, that's just part of the communication. It doesn't present either an issue of open meeting law or public record, other than as long as it's on your device or in your possession, it would be available to public to see it if they made a request for a public records request.
I have a question about that.
Please, you'll have to step up to the microphone so we can record it for the record. Thank you.
Jim Campbell on the Fire Board of Appeals. To comply with the open meeting law and have that communication email-wise, if you had a one-time communication and you printed it out and gave it to your city representative, that both back and forth, whatever it was, would you then be basically making your city representative responsible for that, and you wouldn't have to retain that any longer?
No, and I would say that the retention schedule as it relates to receiving public information, unless it's on certain items of business, that the city gets where they have to retain it for a certain amount of time. But if it's just, hey, someone's loud, I think you need to stop them, or this building is unsafe.
More of a tag to get rid of you having to keep it on your device or something like that. You give it to the city, and then the city would be the
custodian. But what I'm saying is, as long as it's also on your device, you're still a custodian. So there's two custodians. But
Thank you.
Giving it to the city and then deleting it, that's fine.
Any other questions or concerns? City Council? No? Any member of the public or the board members? Then this open meeting law workshop is adjourned. And again, have a very Merry Christmas and a Happy New Year. And thank you all for serving to the city. We appreciate your volunteer and efforts. Thank you.